Thank you, Margaret, and hello and welcome to all of you. I'll add one update to the bio that Margaret presented. Since July of 2015, I've served as the Appeals Bureau Manager, serving as the manager and the position that commonly would serve as a Chief Administrative Law Judge and supervisor of the 15 administrative law judges, or ALJs, and support staff in the Unemployment Appeals Bureau of Iowa Workforce Development. So I'm speaking more or less in that capacity today. I will provide the CLE activity number. It is 251691. Again, the CLE activity number is 251691. We'll provide that number at the end of the presentation, as usual, of course. The materials you received and what you're viewing on your screen as you listen to this presentation is, as it's entitled, Selected Issues in Unemployment Insurance Adjudications and Administrative Appeal Hearings. This is the updated version of a well-loved and frequently requested outline that the previous Chief Administrative Law Judge for Unemployment Appeals, Dan Anderson, had prepared. So this is based on his outline and, of course, is updated as of early 2016. So feel free to peruse these materials and keep them as a general reference. Of course, as you hear all speakers say, this disclaimer is current as of the date on it, which was March 29th, 2016. So things do change and may change in the future. So please keep that in mind as you're using these materials as a general reference. Before I begin talking through those materials, I want to provide some other general information, what I call some top 10 tips for dealing with unemployment appeals matters. These are applicable for both attorneys representing claimants or the employees who are seeking unemployment benefits, and attorneys who are representing the employers. Since this is the Government Practice Section's sponsored program, I'll talk a little bit about government employers and that really special relationship with unemployment insurance. As some really basic background, unemployment insurance is exactly that. It's intended to be there in case you need it, just as you might purchase car insurance or homeowners insurance. Unemployment insurance is part of a trust fund and is fully paid by employers. The claimants or the individual employees do not pay into the unemployment system, despite the fact that some of them believe that they do and mention that fact to me from time to time when they're unhappy with the result for one reason or another. The unemployment insurance system is part of the Social Security Act, so it dates back to the 1930s and is a federally run, federally mandated program under the jurisdiction of the U.S. Department of Labor, but is administered in each and every state, including Iowa. So in general, what's called the Iowa Employment Security Law, Chapter 96 of the Iowa Code, generally governs the unemployment insurance system, and then the relevant sections of the Iowa Administrative Code, which is where the details, and we all know the devil's in the details, are located, is 871, Iowa Administrative Code, Chapters 23, 24, 25, and 26. So those are the general places to do your research when you're preparing for unemployment insurance appeal hearings and other matters regarding unemployment insurance. As I mentioned, unemployment insurance is fully funded by employers. Most employers pay what's called a contribution, and it is a tax, and at a certain rate based on the industry that employer is, the industry in which that employer is classified, I guess I should say, under the national classification system, and also dependent on their employment experience, which means more or less they have a lower rate if they haven't paid out that much unemployment benefits in the past years or so, and is a higher rate if they're in an industry that tends to pay out more unemployment insurance benefits, or because of that employer's particular experience in paying unemployment insurance benefits. Government employers can choose to be contributory employers, or in other words, a government employer can choose to pay into the system at a certain rate, or a government employer can choose to be what's called not a contributory employer. The words escaped me at the moment. But a government employer can choose to pay on a one-time only basis, or pay directly only when an employee applies for or claims unemployment benefits and is granted unemployment benefits. So it's important to know whether or not your government clients are contributory employers or in the other category. Now, if you just the basic tips for preparing and participating in unemployment insurance benefit appeal hearings. It's a very quick process. It's very important to note the deadlines, to pay attention to the notices you receive from Iowa Workforce Development Appeals Bureaus, to prepare for the hearing, and then to participate in the hearing. We call these administrative hearings simple, speedy justice. So the first deadline is the deadline to appeal from that initial adjudication decision, that initial decision that either granted or denied benefits for the claimant, and either the claimant or the employer may appeal any decision. The deadline to appeal that initial decision is 10 days, and that's 10 calendar days. So it's very important to pay close attention to that decision and make a very quick decision whether or not you want to appeal. The appeals can be filed using an online form that's found on the IWD or Iowa Workforce Development website. You can file the appeal via fax. You can file the appeal via email attachment, or good old U.S. Postal Service mail. But it's very important to meet that deadline. The 10-day deadline is jurisdictional. We're doing a much better job over the last year in particular, and really over the last year and a half, in setting up the hearings in a very timely manner and completing the hearings and the decision within a very timely manner. So after you file the appeal, you can expect to receive a notice of hearing, within a few days to a week's time, and that hearing itself will be scheduled about 10 to 14 days after the date the appeal is received. We are required to provide approximately 10 days notice before the hearing, but we are scheduling them pretty quickly after that time period. It's important to read the notice of hearing and follow the instructions on that notice of hearing. This may sound very basic, but you'd be amazed at the number of people who don't read the notice of hearing carefully and then end up missing the hearing and missing their opportunity to present their case, whether they're the claimant or the employer. So it's important for you to advise your clients whether they be the employer, a government employer, or the claimant, the person seeking benefits, to make sure they share that notice of hearing with you once they receive it. If your appearance is on file, or if you're the attorney who filed that initial that appeal, then you should receive a copy of the notice of hearing as well. What we find on a regular basis is that either the employer or the claimant filed the appeal themselves, and then the attorney's appearance comes later. The vast majority of the unemployment appeal hearings are conducted over the telephone. The parties are sworn in, they testify under oath, exhibits are received, hearsay is admissible, although we expect the hearsay evidence to be reliable and relevant, of course, to this particular proceeding. It's important for both parties to prepare quickly for the hearing. Once you receive that notice of hearing, think about what witnesses are important to testify. Think about the documents, recordings, social media postings, whatever you believe would be relevant to help you prove your side of the case is important to submit as soon as possible. It probably goes without saying, but you'd be amazed how often this happens. So it's very important to actually participate in the hearing, to have provided the accurate telephone number for the vast majority of our hearings, which are telephone hearings, to the Unemployment Appeals Bureau, so that the administrative law judge can call you at the correct number for the hearing. The ALJ will call the parties within, right at 10 a.m. or within 5 or 10 minutes of the scheduled start time for the hearing. Our hearings are all scheduled on the hour, and most are scheduled for a 1-hour time slot. If there's reason to believe ahead of time or reason to know ahead of time that a longer time period is needed, if it's a hearing with an interpreter, or it's a hearing where one attorney or the other has given us warning that there might be quite a few witnesses, or another reason for an extended time period for that hearing, we will schedule the hearing accordingly. But it's better for us to know sooner rather than later. Of course, it's important to allow an in-person hearing. If you prefer an in-person hearing, our rules basically require that if you want an in-person hearing, you receive an in-person hearing, even though the vast majority are conducted over the telephone. In-person hearings are scheduled in various locations around the state on an as-needed basis. One location is in Des Moines, Iowa, at our main office, and those in-person hearings can be scheduled pretty quickly. All of the 15 ALJs who hear unemployment cases are located or working in the office at the main administration building for Iowa Workforce Development at 1000 East Grand. But certain ALJs travel to the other locations around the state as I mentioned, an as-needed basis. So if your employer client or your claimant client are located in other parts of the state, and you believe that it's better for one reason or another to have an in-person hearing, please make that request when you're filing the appeal, if you are involved at that time, or make that request for an in-person hearing as soon as possible after the appeal is filed. And it's helpful for us to hear from you the location that you believe is the best place for that in-person hearing. The in-person hearings are scheduled at the location closest to the non-requesting party. So usually both parties are in the same area because most people live where they work or work where they live. but in case the claimant has moved away from that location, or perhaps the employer's headquarters are located somewhere else, from time to time there's some disagreement on the proper location for the in-person hearings. We hold in-person hearings in Burlington, Carroll, Cedar Rapids, Council Bluffs, Creston, Davenport, Dubuque, Decorah, Fort Dodge, Marshalltown, or pardon me, not Marshalltown, Mason City, Ottumwa, Sioux City, Spencer, and Waterloo. So those are the designated locations for our in-person hearings. As I mentioned, the hearings proceed in a certain order. They are somewhat informal, but all the witnesses are sworn in, testify under oath. Of course, as in any trial or other contested case proceeding, it's important that the participants follow the judge's orders and directions, that one person testify at a time. As helpful as your clients might want to be, it's important that only one person testify at a time. One aspect of the unemployment insurance appeal process is that the administrative law judge takes a very active role in these cases. The ALJ is most likely to ask the initial questions of your client relating to the beginning and end of the employment relationship. We'll ask some other basic questions about the business operation or the way that this government entity operates. So be prepared, even though you are representing your client, of course, during this proceeding. So just be ready, and be helpful for you to prepare your client for that circumstance, that the ALJ will take a very active role in questioning all of the witnesses. Of course, after the ALJ is done asking those basic questions, he or she will allow you to ask questions of your clients. All witnesses will have a chance to add additional relevant information that they believe is important to help them prove their case. And each party will be allowed to cross-examine the other participants in the hearing. So each party will have the chance to ask questions that the ALJ asks. Each party will have the chance to offer additional testimony. Each party will have the chance to ask questions of the other party, and each party will have the chance to provide rebuttal testimony or additional information. Each party has the opportunity to submit exhibits, as I mentioned earlier, and these exhibits consist more often of documents that we might not have considered as possible many years ago. Several employers submit surveillance video. The employment relationship may have ended through a text message or a Facebook post, or relevant evidence might occur in a YouTube video, in addition to the traditional employee handbook, attendance policies, signed resignation letters, or signed discharge letters, things along those lines. Whatever information or documents, exhibits you believe would be relevant to the case, go ahead and submit those to us. We also ask that you provide all of the exhibits to the other party. As I mentioned earlier, these occur pretty quickly, and so the quicker that you can provide exhibits to us and then also to the other party, whether you're representing the employer or the claimant, the more efficient the process can be. Most of the ALJs in the Unemployment Appeals Bureau are issuing their decisions very quickly in a timely manner now after the hearing. So you can expect to receive the ALJ's written decision within a few days to 14 days after the hearing. The written decision is mailed to both parties. The decision will comply with Chapter 17A of the Iowa Code. It will include a statement of the case, findings of fact, which are the facts, the credible, relevant evidence, according to this ALJ and the evidence presented during this particular hearing, including the testimony and any exhibits that were admitted. The decision will also include reasoning and conclusions of law, and then the actual decision or outcome denying or allowing benefits. Of course, either party may appeal from the ALJ's decision if either the employer or the claimant disagree with that ALJ's decision. The next appeal deadline is also pretty quick. It's 15 days. The next level of appeal is the Employment Appeal Board. The Employment Appeal Board is another part of another state agency, part of the Department of Inspections and Appeals. The 3 members of the Employment Appeal Board are individuals who are appointed by the governor. The EAB or Employment Appeal Board members are supported by staff attorneys. The Employment Appeal Board will review the entire record that was presented to the ALJ during the appeal hearing. So the EAB listens to the hearing record and reviews the exhibits that were submitted in connection with the appeal hearing and reviews the ALJ's decision. If I didn't say it earlier, I'll say it now and probably say it again. The place to make your record is at the Appeal Bureau level. The place to make your record is during the appeal hearing before the ALJ. All further appeals include reviews of the record as it's made at the appeal level. So as I mentioned, the Employment Appeal Board will listen to the hearing recording and review the exhibits and then make its own decision based on its assessment of credibility of witnesses and its assessment of the important facts of the case and of course the law that applies to those facts. The Employment Appeal Board can affirm the ALJ's decision, and the EAB does affirm the ALJ's decision the majority of the time. However, the EAB can also reverse the ALJ's decision, and they do make their own findings of fact and their own credibility assessments based on the way they hear the evidence, which may differ from the weight or the credibility that the ALJ viewed. And the EAB can also remand the matter back to the UI Appeals Bureau, which they do on a somewhat regular basis for another hearing. So don't be surprised if you've participated in the hearing with the ALJ, one party or the other appeals to the EAB, and then you're back down at the UI Appeals Bureau for another hearing for one reason or another. The Employment Appeal Board usually specifies the reason for any remand to the Employment Appeals Bureau. The EAB might also modify the ALJ's decision based on, again, its view of the facts and the applicable law based on its listening to the hearing recording and reviewing the documents and exhibits that were submitted. Further appeals, if you're displeased with the EAB's decision to affirm or reverse the ALJ's decision, are to the district court. And that deadline is 30 days for a petition for judicial review under 17A of the Iowa Code. Another very important fact that I want to bring to your attention, the ALJ decisions in unemployment insurance appeals are public records. The decisions are posted on the Iowa Workforce Development's website. We're required by Chapter 17A and then by an administrative rule to make the ALJ's decisions available to the public. And so the way that Iowa Workforce Development determined these decisions would be available to the public is by making them available online on IWD's website. And that process has been in place since 2004. So all the ALJ's decisions since 2004 can be accessed on the IWD website, unless, of course, there are decisions that are sealed for one reason or another. But the vast majority of decisions are accessible on the website. What we learned over the past year or so is that these ALJ decisions are also accessible via Google searches or through some other search engines. As many of you may know, if you read the Iowa newspapers or observe broadcast media from time to time, the ALJ decisions might also be reported, unemployment insurance decisions might be reported in a newspaper or included in a broadcast. So those are the basic 10 tips. I guess one other thing I do want to mention, if your client needs an interpreter, of course an interpreter will be provided for the hearing. That's another fact that would be helpful to know sooner rather than later. It'd be very helpful to know from you the language needed and then also the country of origin. As you may or may not know, last time I looked, as reported by the Iowa Department of Human Rights, over 180 languages are spoken now in the state of Iowa, and we've, well, I usually take on the task of searching for interpreters in unusual languages when needed, and I'm learning more and more every day about the wide range of languages spoken by many individuals working in the state of Iowa who are involved in unemployment insurance appeals and searching for appropriate qualified interpreters for all of those individuals. So knowing the specific language and country of origin ahead of time will help us make sure we're adequately prepared for the hearing and with an appropriately qualified interpreter in that language. And I know we'll hold questions till later, so if you have any questions, you can send those in as per Christy's instructions, and I'll try to get to them later. Now on to the materials that you were provided. So I do quite a few presentations around the state for various groups, HR directors, SHRM groups, and other groups associated with the local Iowa Works offices. And the number one question I receive at most of those presentations is, how do I prove a discharge for a misconduct case? So I'm sure as all of you know, you can imagine my answer. I can't tell you that. It all depends. You know, of course it all depends on the facts and circumstances of each situation and the credible, relevant evidence that's presented to the ALJ during the appeal hearing. However, the general rules on or definition for discharge for misconduct can be found in Iowa Code Section 96.5, subsection 2A, and in Iowa Administrative Code Rule 871.24.32 sub 1. However, Iowa's appellate courts have further defined the burden of proof or the definition for discharge for misconduct that would disqualify a person from unemployment insurance benefits. I guess one important point to make in this context, and this is a point that I make when I speak to non-attorney groups, it's always the the end of an employment relationship is between the individual employer and the individual employee. Iowa is an at-will employment law, or an at-will employment state in general. So the decision to part ways with an employee, or an employee's decision to part ways with an employer, is is their choice. The decision whether or not an individual is eligible for unemployment benefits is the job of Iowa Workforce Development Unemployment Insurance Division, and specifically the Unemployment Insurance Appeals Bureau. So we decide whether or not the person is eligible for unemployment insurance benefits. The employer and the individual employee, decide whether or not the employment relationship continues or ends. So in order to prevail in a discharge or misconduct case, of course it is the employer's burden of proof in these particular cases. The final incident that led to the end of the employment relationship is the most important act. Was it a current act of misconduct? Was it the last act in a series of acts? That is also relevant. But the final act that led to the end of the employment relationship is the most important. Actions that occurred after the end of the employment relationship is not necessarily relevant, and some previous actions might be relevant depending on the similarity between those prior actions and that final act of misconduct. The cases are included in the materials you received, so I won't go through all of those. However, I do want to bring to your attention a recent Iowa Supreme Court case that is not included in this outline. This is an extra bonus for actually attending the CLE. You get to hear the discussion about this case. It's Irving versus the Employment Appeal Board. The Iowa Supreme Court reached its decision in May of 2016. The citation for the Irving versus Employment Appeal Board, or EAB, decision is 833 Northwest 2nd 179. Again, that's 833 Northwest 2nd 179. And Irving is IRVING. In case you're looking for it via Westlaw name search or something like that. There's lots of takeaways from this decision. I've read it at least 10 times and gleaned something new and additional from it each time I read it. But my basic takeaway from it is, as it relates to, how do you establish a discharge for misconduct that would disqualify a person from benefits, or if you're representing the claimant, to show that the person is qualified or still is eligible for unemployment benefits, even though his or her employment was terminated. The Irving decision makes it clearer that the misconduct must be intentional. So it's up to the employer, who bears the burden of proof in these cases, to show that that final act that it considers misconduct, enough misconduct to end the employment relationship, was intentional. Now, a very common type of discharge for misconduct is attendance, and that's not necessarily intentional or unintentional. The important point to show in an attendance case is that the absences were excessive and unexcused. It's important to show that that last absence that led to the discharge or termination of the employment relationship was unexcused. So absenteeism must be both excessive and unexcused. Of course, the meaning of the word excessive, the number of times a person can be absent or tardy, it depends on the facts and circumstances of each particular case. Another common area for discharge for misconduct is insubordination. Failure to follow reasonable instructions, failure to perform a specific task, those kind of facts. Now again, reading the prior cases in light of the Irving case, it's important to show that that insubordination was intentional. It's also important to provide context of the employer's day-to-day business operations, business purpose, to show that that action or inaction was detrimental to that particular employer's operations. Sometimes language, in other words, profanity, is a reason for an employee to be discharged. Again, the employer bears the burden of proof in this case. Why was this particular language so unsuitable that it should justify denying unemployment insurance benefits? So it's important to be able to provide context and to show whether or not this was commonplace in this particular workplace or whether it was completely unexpected and inappropriate. Sometimes we have cases where employees were not getting along and there's a physical altercation of some type, either in the workplace or outside the workplace. So both of these circumstances could constitute disqualifying misconduct, but it's important to show the details of the actions or inactions and to show intent as best you can. Now, another category is gross misconduct. If an employee is convicted of an indictable offense, then that is disqualifying misconduct. Now, as I mentioned earlier, the unemployment insurance process runs very quickly, so quite often you might not know whether or not the criminal case is resolved by the time of the unemployment insurance appeal hearing. The next major category or reasons for the end of an employment relationship is whether or not the employee voluntarily quit or left that employment for his or her own reasons. Now, in general, the claimant or the person claiming unemployment benefits, the former employee, bears the burden of proof to show that he or she is eligible for unemployment benefits in a voluntary quit situation. So in general, claimants who voluntarily leave employment without good cause attributable to their employer are disqualified from unemployment benefits. However, our administrative rules include about 40 different categories or ways that you can voluntarily quit your employment. In some of those cases, the claimant would not be eligible for benefits or would be disqualified from receiving unemployment insurance benefits. In some of those categories, the individual would be qualified or eligible for unemployment benefits. What are some of the ways that a person could voluntarily quit a job but still be eligible for unemployment benefits? The general rule is, or what we follow is, these would be attributable to the employer, or in other words, something the employer did or something about the work environment caused the person to quit the job. So sometimes it's a substantial change in the contract of hire, and what that really means is you're hired to do one job at perhaps one rate of pay, perhaps one set of working hours, and then there was a substantial change. And I'll let you review those cases on your own if you were faced with that situation. If the work environment was intolerable due to harassment or health and safety concerns or some other reason, then that might be a qualifying reason to quit a job. In other words, those would be environmental factors that are attributable to the employer. If a person quits to accept other employment and then for some reason or another that employment ends prematurely, then the individual may be eligible for unemployment even though he or she quit that first job for his or her own reasons. If an individual is an employee of a temporary staffing firm, then that's a whole category in and of itself. And those employment relationships are governed by Iowa Code Section 96.5, subsection 1J. I presume that none of the government practitioners would be in or represent temporary staffing firms, but just in case, I know some government agencies use temporary employees and may obtain the services of those temporary employees through temporary staffing firms. So I'll just cover that briefly. In general, at the completion of an assignment with the temporary staffing firm, the employee or claimant must contact that firm within 3 business days and seek reassignment with another position in order to remain eligible for unemployment benefits. So usually these temporary staffing firms require an individual to sign an agreement that they understand this policy and the fact that they are required to request reassignment within 3 business days after an assignment ends. And the issue before us usually is whether or not the person did make that contact within those 3 business days, how that contact took place, and whether or not the individuals knew that the assignment was ending. And this is a very specific statute that applies to this particular employment relationship. So if you're faced with this situation, I advise you to read that statute carefully and then make sure you're aware of all of the steps in the process and following those steps, or be ready to present evidence on each of those steps. Another somewhat common situation is the person either refused suitable work or refuse to be recalled to suitable work. And that if you're faced with that situation, I commend the materials or again reading the plain language in the statute. Now, a person can be employed, in a part-time job and a full-time job, which is somewhat common. In Iowa, a person might have 2 or 3 part-time jobs. What happens when he or she leaves one job or another job. When a person files for unemployment benefits in general, each employer, I should say each and every employer, within their base period, which is this year-long calendar year or a 4-quarter time period, is notified of the unemployment insurance claim and has the chance to protest or disagree that person is eligible for benefits, or can just agree not to protest the claim. So it may happen that an employee left your employment more than a year ago, files a claim for benefits, and your client employer is notified and is surprised to hear about this person's unemployment insurance claim. So if your client employer, employed this individual full-time or part-time, you'll still have the opportunity to protest that unemployment insurance claim if you believe that the person is not qualified for benefits based on the way that he or she left that employment relationship. So just because you may have employed someone part-time or for a short time period, it's still important to participate in the unemployment insurance benefit process to ensure that your rights are protected. And I won't review all the details of part-time employment and partial employment and eligibility and so on. I'll leave that to your reading. I'll move on because we're running short of time. So as I mentioned before, there's so many ways you can voluntarily quit a job, and many ways that disqualify you from unemployment insurance benefits, and other ways that might qualify you for unemployment benefits. So I commend those situations to your reading. Another very specific statute is the drug testing statute. So if any of your employer clients do random drug testing or incident-related drug testing, it's very important to be familiar with each and every requirement in Iowa Code Section 730.5 and to be ready to present evidence during an unemployment appeal hearing on whether or not the employer complied with each and every step in that statute. Whether it's a random drug testing policy or incident, how was it random? How did the testing occur? Was the individual provided the opportunity for a split sample? Was the person given the opportunity to meet with the medical officer at that place of employment? Was the individual notified via certified mail? I mean, it's very important to be familiar with every step in that process and to be ready to present evidence on whether or not every step in that process was followed. Another special situation, but it seems to be more common than you would have expected, are situations with vacation pay, severance pay, and pensions. So a person may be eligible for unemployment insurance benefits based on all of the other details we've discussed and reasons we've discussed. However, some types of payments are deductible from their unemployment insurance benefits. In those situations, it's very important to have evidence from both parties, from the claimant and the employer. If it was a vacation payout, what time period was covered by that vacation pay, because that makes a difference in when the individual would become eligible for unemployment insurance benefits and the amount of those benefits. So if you're representing a claimant or employer, it'd be very helpful to provide that type of information. If there was a severance agreement and severance pay, the detailed terms of that severance agreement are very important for the administrative law judge to have in the record in order to make an accurate and well-reasoned determination on that situation. So those are important documents to submit if that happens to be one of the issues on the appeal. I talked quite a bit at the beginning about the general procedures. If you are handling an unemployment insurance appeal for the first time, or you don't do them very often, I would suggest that you read through Chapter 26 of Iowa Administrative Code 871, specifically IAC Chapter 26. Those are the procedural rules for the unemployment insurance appeal hearings in Iowa workforce development. So that's where you can learn how to submit exhibits, how to request a subpoena for witnesses or subpoena for documents. We do allow discovery. It's a shorter time period than the discovery under the Iowa Rules of Civil Procedure. Again, this is a pretty quick process in general. So it's important to be familiar with the rules. Remember that it's still a legal proceeding, even though it is more informal than a typical court proceeding. And remember the very short deadlines for initial appeals and then for appeals to the Employment Appeal Board. One other fact I'll mention before we open it up for questions. The employer's participation in that initial level in the fact-finding interview may make a difference in whether or not that employer's account, as I mentioned at the beginning, the contributions that employers make to the Unemployment Insurance Trust Fund, are whether or not that employer is responsible for the charges. So if you're representing employers, then it's important to be familiar with 871 Iowa Administrative Code 24.10 for those requirements. So with that, I will open it up for questions.
We do have one question. Other than the 10 tips, is there anything else that helps ALJs make a case go smoothly?
Cooperation and respect, basically, for the proceeding. You know, making sure the witnesses who, you know, the first-hand witnesses, eyewitnesses, whatever term you want to use, are there and ready to provide, you know, basic, succinct answers to the questions. The basic information that the ALJ will always want to know is the first date of employment, last date of employment, you know, first day worked, last day worked, what was the job title, was it full-time or part-time, you know, what were the general job duties, and those types of questions. You know, how did the employment relationship end? Who decided that the employment relationship would end? You know, those kind of basic questions. So if the witnesses, the participants, could be ready with answers to those questions, that would be very helpful. Another important matter is just making sure that the individuals listen carefully, to the questions, and it sounds silly to say this, but one person speak at a time. Make some of these smaller employers, mom and pop operations, want to speak for each other and can't really do that during a hearing, even though the nature of telephone hearings seems to lead people to believe that it's a casual conversation and it's not actually a hearing, formal legal proceeding. So the more attorneys can, perhaps prepare their clients for that fact, the better. Hope that answered the question.
That's the only question I have.
Okay. I just then also mention, the Iowa Workforce Development website has quite a bit of helpful information. There are handbooks for geared towards claimants and for employers that are available online. Those include a lot of the basic information in simpler terms than you might be receiving in this handout. And we encourage appeals to be filed using the online form that you'll be able to find on the Iowa Workforce Development website. That includes prompts for some of the details I mentioned earlier. If you want an in-person hearing or a telephone hearing, if an interpreter is needed. It includes a prompt for an attorney to include his or her name and contact information. And so that just makes the process simpler and more efficient for us to go ahead and process the appeal and prepare the hearing notice. Any other questions?
Let's see, there is another one. What determines an absence if an absence is excused? What factors can we consider?
Okay. An excused absence is generally due to illness or reported illness, emergency situation. An unexcused absence includes matters of what are considered personal responsibility. So like, if your car broke down, you had trouble finding childcare on a daily basis, you overslept, those are not excused absences. But, needing either your own illness or like the illness of an infant child or a medical emergency of some sort, those are considered excused absences.